Welcome to Expert Views on ADR Ever, a podcast about simplifying the traditional African method of settling disputes or the appropriate dispute resolution ADR in a bid to attract more users to settle their disputes or conflicts with mediation, ombuds, collaborative law, arbitration, restorative justice, early dispute resolution, negotiation, conciliation, and of course, early neutral evaluation. My name is DrChinweEgbunike, the marketing liaison of Ombuds Day 2024 American Bar Association Dispute Resolution and the host of Expert Views on ADR Ever video podcast show. I'm delighted to welcome Tony Guise to the Ever show. In different capacities, Tony has been at the heart of every major civil justice reform of the past 30 years. Notable successes include the formation of the Civil Justice Council, CJC, in 1997, the campaign for new court accommodation in 2007 that became the rules building, and in 2013, costs budgeting. Tony ceased to practice as a commercial litigation solicitor in 2016. He works full-time as the director of disputes e-filing and online dispute management platform, as well as campaigning for civil justice reform. He wears many hats, so I've left the link to his profile below. Let me stop recording now. Welcome to the show, Tony. Such an honor to have you.
Oh, thank you. Thank you for inviting me. The honor is all mine, Chinwe. I'm delighted to be here and to be talking about my favorite topic, which is I was ADR and technology and the future of, as it were, multiple routes to resolution, which I think is going to be really transformative for the civil justice system in England and Wales. I was interested, actually, by the way you introduced the topic by reference to the African method of settlement. I was intrigued by when I was preparing for another podcast a few weeks ago to read about the my interviewer's Ugandan background, and the traditional tribal method of settlement resolution via elders was in place until we Brits arrived, unfortunately, and introduced the common law. Sorry about that. And then that disrupted that process, which had worked so well for so long. And then, of course, the common law brought what it always brings, which is ossification and delay. But I think Uganda's overcome that now, of course.
Okay, thank you so very much for highlighting that. That's the same thing in Nigeria as well. But however, the traditional African method of settling dispute is still very much alive and active. Anyway, we can talk about that later. But without further ado, the first question is, how has ADR enhanced access to justice? Sorry, can you please sort of give us an overview of what ADR is and how it has enhanced access to justice?
Yeah, of course. Well, ADR, it's the long-established abbreviation for alternative dispute resolution, alternative signifying something other than the binary offer from courts, win, lose, and originated in the United States of America, of course, we say, but as we just mentioned, in fact, forms of ADR first evolved in Africa, of course. So this term ADR envelops the concepts of mediation, neutral evaluation, adjudication, and some would say arbitration, but some might disagree with that because they say, well, arbitration is, again, another form of binary solution. You win or you lose. Whereas, for example, mediation, the mediator is facilitating or enabling an outcome, which is which both parties, all the parties, support. So it's traditionally stood outside the dispute resolution mainstream in England and Wales. It received a shot in the arm when Lord Wolfe undertook his inquiry between 1994 and 1996, and he said we must have more ADR. This encouraged all of my colleagues to say we must become mediators. So they all became mediators, only to discover that there weren't that many cases to actually mediate. And so when you ask how has it enhanced access to justice in the UK, in England and Wales, I would answer not a lot so far, not a lot. So in that sense, let me give you some numbers. There is a biannual audit undertaken by the Centre for Dispute Resolution, CEDA, and that showed, I think, the last time it ran, which was, I think, last year, it was published, about 18,000 mediations every year. But bear in mind, this is civil and commercial. Doesn't include family, doesn't include workplace mediations, doesn't include mediations of those bringing claims for entitlement to local authority support for special educational needs and those with disabilities, children, pupils. So, I mean, there is a great deal of family, there's a great deal of workplace mediation taking place, but how much is unclear. It's certainly in the civil commercial field, which is my background, not a great deal. And the reason for that, I think, is because when commercial litigators, civil litigators earn their living by reference to the billable hour. Now, the more billable hours they bill, the more they earn, and the more they hit their billing targets. And that can only really be achieved if you run cases, well, typically to the door of the court. Because at that time you've had a case running for 2-3 years, maybe, billing happily away, getting paid, and then, well, we want to remove the uncertainty of the trial, so the settlements at the door of the court are the norm. So has ADR enhanced access to justice? Thus far, not an awful lot, I would say. And bear in mind, you have 1.2 between about 1.2 million cases, civil cases, issued in England and Wales every year. And if you say, well, in civil, if the CEDA audit is to be believed, and no reason why it shouldn't be, there are only 16,000, 18,000 mediations. So we can see immediately that whilst it has an impact, that has been, in my view, limited.
Okay, so how about when you compare with litigation?
How much
impact?
Well, in terms of disrupting the litigation cycle, you mean?
The cost and time frame in litigation.
Yes. Oh well, to compare the two is like comparing chalk and cheese. So in one scenario, the litigation route, you have the parties at loggerheads, do or die, as it were, and in the mediation context or other mediated processes such as evaluation or that sort of thing, you are bringing the parties together to find a solution, not to impose an outcome, but to find a solution. And that is why most of the time in mediated outcomes, there isn't any question about enforcement, because both parties have agreed a solution, and that solution can be much, much wider than the outcome in court, where if you win, you get damages, you might get some kind of injunctive order to do or not do something, those sort of things. But in the mediation context, of course, one can have changed terms of trading between businesses. In other words, you can encourage a continuing relationship, which courts simply are not there to do.
Okay, thank you, Tony. So how about technology? So, what is your view? Do you think technology has played a significant role in enhancing access to justice in England and Wales?
Well, this is something to which I've devoted very nearly half my life, as you know, to introduce effective IT into the civil justice system of England and Wales. So one has to look at, firstly, the courts. And in 2015, the then Chancellor of the Exchequer announced a very large sum of money to enable the courts to be modernised. It's called the Modernisation Program.
Okay.
And that was going to transform court processes. And unfortunately, the exact plan for doing that can't be found. That has been misplaced. According to the National Audit Office, that's what they were told when they asked to see the plan last year or the year before, when they did another review of progress.
Okay.
Sorry.
No, carry on. I said okay.
Yeah. A modernisation was supposed to be finished by 2020, and it's been extended and extended. A little more money has been put into it. The funding was £1.4 billion, which is an awful lot of money for civil justice and also for criminal justice as well. It covers both civil, family and tribunals and crime. So let's be clear about that. It's now extended until March 25, with some programs not finishing until the beginning of 26. And I don't propose to explore, unless you want me to, which I can do, all the reasons for the delays and the problems. The effect on justice is, I think, what you want me to explain. And so what we have at the moment is a system where you have three portals: the online civil money claims for fixed sums, debts, that sort of thing; something called the damages claim portal or pilot, DCP, that is for unliquidated or cases where the sums have to be worked out because there's a breach of a contract and the consequences in terms of monetary loss have to be fixed. And then there's something else called C-file, which is an abbreviation that stands for Court's Electronic File. And that is in the rules-building jurisdictions, the Commercial Court, the Court of Appeal, family, and to a degree in tribunals. And that is a Thomson Reuters product called C-Track. And it's a bit clunky, but it's been there since 2015. And the problem with all of these systems, with one exception, which I'll mention, is that they are not end-to-end. So they are building them out, but they are typically you'll get to a direction stage, and then the process will fall back into the paper system. So the effect of this is that where you have a system part digital, part paper, you have an even worse situation than you had when it was all paper, because the paper processes slow things down. The paper file becomes lost. We have fewer judges now than we had when we started in 2015, because there is a judicial recruitment crisis, particularly in the county court, in what is known as the district judge bench, the first rung of the civil tier of the judiciary. And there aren't enough of those judges, but that's where most cases are heard. So you have too few judges, files that go missing, and the result of this part paper, part digital system is that the waiting time for first hearing, which in 2015, for a first hearing in the county court, in the small claims tract, that's to say for claims less than £10,000 in value, was 33 weeks in 2015. It's now 55 weeks on average. In some courts, it's 100 weeks. You know, I have to say, for balance, in some courts in Wales, it is about 36 weeks. But what happens is, if you say, well, I can get to court in just over a year, okay, but then the paper file will become missing, or the judge will become missing, or they'll both be missing. And then there's an adjournment introducing a further, let's say, 26 weeks. And that has all led to an almighty backlog, the backlog. And that's probably about 600,000 cases in civil. And it is enormous, and it is not enough known, which is why I'm so grateful to you for this, the opportunity to talk about these things. It's very rarely covered. The criminal justice backlog is often covered, but the civil, which is far worse, is not often mentioned.
So in essence, technology has enhanced access to justice in England and Wales?
I think in terms of the courts, technology has hindered access to justice, because it has justice delayed is justice denied. So at the moment, until it's built out, and the deadline for the finishing goes back and back all the time. So what will save, I think, the people in the backlog whose lives are blighted, whose livelihoods are blighted by this infernal backlog, what will save them is the realization of Lord Wolf's idea of pre-action work, everything being front-loaded before you issue proceedings. So the plan is that there will be reformed pre-action protocols, which will have an obligation to comply with them, and will be introducing, in effect, mandatory ADR.
Okay. So how about the ODR, the online dispute resolution?
Yes. Well, you're ahead of me again. I was just about to say that the idea, in addition to introducing mandatory mediation, is that mediation, for example, or it could be evaluation, will be managed online using platforms such as Disputes e-filing, online dispute management platform, and ODM. And so we have estimated, I don't think anybody else has done this work, but we believe that there might be about 750,000 cases in pre-action for civil, just civil, every year.
Okay.
So that's why it has to be managed online. And we believe that we can, using our model of mediation with our mediation partner, ADR, ODR International, we will achieve a settlement rate of about 80%.
Okay.
So this will do two things, and then it's not really understood, because until you do the numbers and you carry it through to issuing, you don't see what's going to happen. So if one is settling 80% or 70% even of cases in pre-action, that will mean a dramatic fall in the number of cases being issued in court. Right? There's two consequences. One, the backlog will begin to evaporate. Will begin to evaporate. The pressure on the district judges will ease, and that will be helped as they roll out the digital systems in court. So that will be enormously helpful. But the other thing, which I don't think many, from my conversation, not many solicitors realize, is that, of course, with a dramatic fall of maybe 50 to 60% fewer issued cases, that's 50 to 60% fewer cases to be worked on by litigation solicitors.
Okay.
So I say that the future for those coming into the profession now, and those already in, lies in pre-action. All the action in litigation will be in pre-action.
Okay.
And so business, and so what we're doing now, we've been asked to talk to insurers and also firms of solicitors over the next, we've been asked, it seemed, over the next 2 to 3 months, but going on to explain what this will mean and how we can help them continue to stay in business, because that's what it's about. They have to make profits out of pre-action in order to continue to provide a service, and it's vital that solicitors are there to provide the service. So does that help on this issue of technology in civil justice? I mean, it's just...
Oh, yeah, so far so good. So what was the purpose of you creating the disputes-e-filing.com, and how has it impacted the legal industry?
Yes. Well, how did I get into this? Well, because I was I had been associated with this campaign to introduce IT in the civil courts, civil justice system for so long.
Yeah.
I was asked in December 2014 by a friend of mine, Patrick Allen of Hodge Jones and Allen, to meet with a friend of his called Andrew Ritchie QC. He's now obviously Mr. Justice Ritchie. Andrew was doing two remarkable things. One, he had devised an arbitration scheme for high-value, complex personal injury and clinical negligence claims. But even more remarkable, he wanted to put that scheme online. And so I had a platform for the court system, and he wanted me to adapt that for his arbitration scheme.
Yeah.
So we won the tender for that work, I'm pleased to say. And by June 2015, we had launched, we'd gone live. What has been the effect of that's how I got into it, and then we evolved. We were working with the CJC on the first ADR review, and that came out. I think there was a workshop in 2018. I spoke out on that occasion. I think January or February 2018, and when the report came out, in that process we realised having arbitration alone wasn't enough. Okay. So we developed a module for neutral evaluation, adjudication, arbitration. Obviously, we had that already, mediation. But in addition, I thought, why are we just focusing on these? We need to look at the whole process. And so we created something called the One Platform, which has a pre-action module. So that's for ad hoc negotiations, correspondence, and presages what they're trying to do now, what the Online Procedure Rules Committee, which we might talk about in a moment, Online Procedure Rule Committee is trying to do. So we deployed all those. We undertook a pilot for NHS resolution, National Health Service resolution. If any of your listeners or viewers are not aware, that is the agency of the National Health Service that manages claims against NHS hospitals in England, and I think possibly Wales as well, but it may just be England. And so we did a pilot. They have a mediation program, and working with Trust Mediation, we undertook the online management of mediations during that year. We trained up both defendant firms and claimant firms like Owen Mitchell, Slater and Gordon, DAC Beechcroft, Clyde & Co. And but the problem, and it is a reflection of what I was saying earlier, that solicitors have a hesitation about mediation because it damages the revenue. Because it shortens. If it's successful, which most mediations are, it will shorten the life of the lucrative litigation. The problem was that there were arguments about which platform to use. And for example, a defendant firm told me that they had proposed using DEF, and a claimant firm in the north east, I don't know which the name of it, they didn't want to use DEF, despite not being owned by any practicing solicitor. I no longer practice as a solicitor. And therefore independent. They viewed it as a defendant platform, and they wanted to use their firm's extranet. Now, this argument about which platform went on, I'm told, for 2 weeks. 2 weeks. And it ended up with nobody agreeing to use any platform, and they exchanged LibreArch files. Isn't that wonderful? Isn't that wonderful? So that was 2019. I like to think things are moving on because now it is going to be mandatory, and the volume, every case has to go through. So it will be a case of using a platform, because unless you can have the turnover of mediations going through, you're not going to be able to make any money.
So if they're making, you talked about making ADR mandatory or mediation mandatory.
Yes.
So does it not remove the party autonomy that it's, you know, well associated with ADR, and that's why most people are really
yes. No, it doesn't remove autonomy. It doesn't remove. They will always have the option, if they want to go on, fight and have their. They will always have their right to issue proceedings. And this was made clear in a case recently, last November, a Court of Appeal case called Churchill and Merthyr Tydfil Borough Council. You may be familiar with that, but in brief, if any of your listeners, viewers have not heard about it, there was an infestation from the Borough Council's land in Merthyr Tydfil, which is a small town in South Wales, onto the land of a private landowner, Mr. Churchill, and he wanted to bring a claim for two things. Firstly, in order to compel the council to remove the infestation. Secondly, for compensation damages, to compensate him for the damage that it caused to his garden. And what the council was saying was, well, no. The first thing you have to do is go through our internal complaints policy, ICP. And the answer to that was, no, we're issuing. They did issue. And then the question was, could the court, at first instance, district judge level, make an order stopping proceedings and requiring the internal complaints policy to be pursued? Well, without going into, which I can do if you want to, but without talking at length about the particular issues there, what I would say is that the district judge said he was constrained, I should say, by a decision of the Court of Appeal, Solicitors in 2004, called Halsey and Milton Keynes NHS Trust. And there was another case with it as well, and that said that you can't make people mediate. And Churchill, what they said, that was only obiter. It was wrong. I think they may have gone as far as that. But in any event, they said you can order a stay to enable what they now call non-court-based dispute resolution. Not quite as snappy as ADR, but it is, if you practice it enough, as I have done, you can get it off the tongue pretty quickly. NCBDR. Now then, this will enable parties to say, we want to stay for mediation or a complaints policy, but there are lots of issues around that. But it's not requiring people to settle. It's requiring them to engage in a process. And if the process doesn't work, then they may continue to have their showdown in court, if they so wish. But there are lots of issues. How long should the process last? Is it appropriate in every case? So it's going to be worked out, and this is the fairness of Churchill, although some have said that it's an absolutely absurd decision. Nothing of the sort. It is a fair decision because it leaves courts in each case to work it out. What is the appropriate thing to do for each case?
Okay, thank you so very much. We're running out of time. It's remaining 9 minutes. So let me just quickly go to the next question. So does the creation of this software suggest a growing interest in ADR in England?
Yes, very much so. When we speak to solicitors, to insurers, to mediation schemes, not only in England and Wales, but also overseas as well, there is a sense that the use of an online platform which has bespoke functionality, for example, for mediations, where you can restrict who sees particular documents in our virtual filing cabinet, so that you can send through our onboard messaging system, you can send confidential communications to the mediator without the other side seeing those. There is a realization that things like Dropbox, extranets, just aren't going to do it in an era of mass resolution. For example, in Nigeria, you may be familiar with the Lagos multi-door courthouse, very long running, brilliant institution, and set up in 2004, I think. And there they have their own backlog now. So we're hoping to work with them to support the digitization of those cases so we can clear that backlog for them. So yes, there is a growing awareness of the need for these platforms.
Okay, thank you so very much. So how much does it cost for one to download or interested parties to purchase the software?
Yeah, so it is on a case-by-case basis, and volume does affect the pricing. So we are a commercial organization, obviously, and the more volume we put through, the cheaper it becomes. So at the moment, we charge £95 plus VAT for each case, and that gives access to all functionality.
Okay. All right. Thank you so very much. So I'm going to come back to a question, a very important question, but let me just quickly ask you this. What is the role of AI in dispute resolution, and what impact does it have on the ADR industry in England and Wales?
Yes, well, this is, of course, the hot question of the moment. I'm glad you asked me. Our view about it is that it may be used, and we're working with Google at the moment to develop an AI that can propose solutions. And in our discussions with them, they say, well, so long as DEF has the volume of cases going through, and we expect once tier 2 comes in about 2 years' time, we expect to have about 250 mediations taking place on our platform every day. So this is the era, this is the kind of mass resolution that I'm talking about, actually. And they say if you've got that kind of volume for 6 months, just 6 months, they will be able to train the AI to propose solutions, to the mediator. But then it will be for the mediator, for him or her, to decide what is the is that an appropriate solution for these parties.
Oh, okay. Thank you so very much. So how secure are the practitioners' data with your software?
Absolutely. Number one question, really. We take the confidentiality of our users' data very seriously. A summary of the data policies, data privacy, data security, is on our information site, disputesfiling.com. Just look down to the regulatory, down the left-hand margin, you'll see there. But in summary, we are GDPR compliant, registered with the Information Commissioner's Office, and we have 3 tier 3 plus data centers in southern England in 3 geographically discrete locations. They are tier 3, so they have an uptime of I don't know, 99.988% of all planned time. So it's tier 4 is the highest, tier 3 the next one down. And they have very big dogs, very big fences, and even more sophisticated things inside the data set. I've never been to the data set. I don't know where they
so you just hearsay.
It's that secret. So there's things that even I don't know about my platform. But yes, so the security is very important. I encourage anybody thinking of using us to visit those summaries on the information site. And we've been assessed by people like AXA, Irwin Mitchell, Clyde & Co., passed with flying colours, a very exhausting process. And if people want to see the full policies, then I'm happy to share those through a secure document exchange.
Okay, thank you so very much, Tony. So final question. I've got other questions to ask, but I don't think we'll be able to cover those questions. Okay. So how effective is disputesfiling.com when compared to other products out there?
Yes. So I judge DEF by reference to our users. Our users and what reaction do we get from them? So in the NHS pilot that I mentioned to you, NHS resolution pilot, everybody loved the platform. It performed very well. We never had any difficulties with it. It is simplicity itself. When you look at it, it's intuitive, drop-down menus, very familiar functionality in terms of tools. So and then when it's being used in mediations, again, the feedback from mediators, from the parties, has always been the same. And the key question is, I always like to ask in feedback is, would you use it again? And the answer always is yes. And the reason why that is because it's easy to use. And in the era of mass resolution, we have focused like a laser beam on the question of removing bottlenecks in terms of allocating mediators to cases, coordinating diaries to make it as smooth a process. That's what people want these days, a bit like using iPhones and things like that. It's got to be very smooth, very easy.
Yeah. Okay, I think we've still got 1 minute remaining. So what is your view about lawyers not embracing ADR? Because research conducted in 2000, 2001, 2020 shows that lawyers are yet to embrace ADR. So what is your view? Is it still the same in this era, in this recent years?
Yeah, I mean, I mentioned some instances from the pilot we did for NHS mediation that illustrated the attitude a few years back. I think that's changing now. People see. I think people recognise this is coming. The Master of the Rolls, Sir Geoffrey Voss, has been flagging what's happening for some time. I saw some unhelpful comments in response to the PACAR, the Rabot decision in the Supreme Court about the Churchill decision, which suggested that still some people who haven't got completely on board with the program. But
Tony,
my experience.
Sorry, it's 1 more minute to go, so it's gonna cut any time from now. Thank you so very much for coming on the show. I truly
my pleasure.
appreciate you.
Could talk all night.
All right, cheers. Take care.
Thank you so much. Take care.